Hi, how are you? Good afternoon. This is Mike Haber, and together with Ed Martinez, we are virtually, digitally, Zoomily at your service. Finally, after several weeks of hiatus, which we both apologize for, unfortunately, we haven't been able to get to the show, and it's troubled us a lot more than I'm sure it has troubled you. That said, let me tell you what we're going to talk about today. We're going to talk about arrests. We're going to talk about the second half of the Fourth Amendment. A couple of weeks ago, Ed and I spoke to you about search warrants. We talked a lot about exceptions to the warrant requirement, why we have a warrant requirement, how the cops can get around the warrant requirement, what the protocols are. And today we're going to tackle the other side. That's the search part of the Fourth Amendment. The second flip side of that coin is called the seizure component. And when you've been seized, you implicate the fourth. When the government seizes you, the Fourth Amendment is implicated. So an arrest is generally defined as the use of legal authority to deprive a person of freedom of movement. Not all police-citizen contacts are arrests. Ultimately, they may reach the point of an arrest. And some of them, even though the word arrest is never used, are actually what we call a de facto arrest, meaning even though the cop didn't say you're under arrest, you were, in fact, under arrest. And if you are placed under arrest, then on several of your constitutional rights are triggered. For example, the first one would obviously be the Fourth Amendment. You have been seized, and therefore the Constitution applies. That will trigger the Fifth Amendment, because anytime you are arrested, if the police want to ask you questions, they have to read you your Miranda right so that you don't incriminate yourself without knowingly doing so. It also implicates the Sixth Amendment. Certainly your right to counsel. The minute that you're placed under arrest, you have a right to speak to an attorney. Statute, in fact, there's a specific Florida statute on that Ed and I will talk a little bit about. And then finally, it implicates the Eighth Amendment, because everybody in the state of Florida who gets arrested, unless you're charged with a capital or a non-bondable offense or you have some other hold, is entitled to bond. So Fourth, Fifth, Sixth, and Eighth are all implicated by any arrest. However, as with most things in the law, nothing is exact or cut and dry. There's an awful lot of gray area. The language that we like to use apart from rules and procedures and protocols are exceptions, loopholes, nuances, and technicalities. And that's exactly what Ed and I plan on discussing with you today. So with no further ado, and let me initially apologize again, because we are appearing digitally. I've got these things in, and so it sounds a little awkward to me. Hopefully it doesn't sound awkward to you, but if it does, I apologize in advance. That's it, Ed. Nice to see you, bud.
Listen, that's okay. Everybody knows you're old. You need those things or you can't hear.
Wait, let me turn up my miracle ear. Maybe I can get a hold of Miracle Max to turn me on my miracle ear.
Miracle Max. That's the guy we need. Maybe he can resuscitate some of my cases.
I always have to tell people criminal defense isn't magic, but if I were Miracle Max, it would be an awful lot easier.
It would be magic. And I like this topic. I'll tell you two of my favorites of this topic are something that in preparation for the case I learned, which why and how can cops, when they have an arrest warrant, break down your door like they do with a search warrant to come get you. And I'm going to address that specifically with the case law and the language. It's right there in front of you. But as usual, law statutes are so complicated, they can't make it simple, that you have to read it 3 or 4 times to really see that it's actually very simple. The other one
sometimes it reads really simple. Like
right.
We have one that we're going to talk about today. It couldn't get simpler than the language in that statute, but reading that statute tells you absolutely nothing you need to know about that law.
Nothing. And apparently there's not a lot of case law on it, because I did research and I couldn't find a damn thing. I found like 2 or 3 things, and none of it were really relevant. But the other one that's really, I really get a lot, Michael, I'm sure you get it from your clients too. Clients will call me all the time and say, you know, they arrested me. And they never read me my rights. I'm like, well, did you say anything? No. I'm like, well, then it doesn't really matter. But there's another component. And I always like to say it this way. When it comes to your Fifth Amendment right, we're going to explain it in detail.
But not today.
No, I'm going to get in detail today about it, because it's very simple.
You can't get too much into detail on the Fifth, because today we're talking about the Fourth. So
but this part, I'm going to make
tangential.
This is simple. The detail is going to be 30 seconds or less. I'm going to explain it to you. When it comes to the Fifth Amendment right, when it comes to your Miranda rights, when it comes to you reading you your rights, it's like baking a cake. Your Miranda rights are the cake. The ingredients that are necessary for your Miranda rights to trigger all have to be there. And those ingredients are custody, being in custody, and being interrogated. And I'll explain that later when we get there. But think of that. It's a cake, and your ingredients are custody and interrogation, eggs and milk, let's say. Flour, eggs, and milk.
For you folks in the audience, let me just clarify what my fruitcake colleague over here is talking about. He's talking about another show that we're going to do on the Fifth Amendment. Today, we're talking about the Fourth Amendment. So, yes, the Fourth does trigger Miranda, the Fifth. But again, it also triggers the Sixth and the Eighth. So let's try and focus on the Fourth. And
all right, let's get started.
So let me give you two things to start with. The first is, again, I want to reiterate the fact that the first component of the Fourth that we've already discussed is searches. And now where we're going to is seizures. So I want you guys to understand that again, everything is amorphous in the law. So we try to create categories to make things more understandable and more simple. And when it comes to the subject of a seizure, for purposes of the Fourth Amendment, the courts have basically identified three different, very distinguished categories of what we call police-citizen encounters. The first, which is the least restrictive, which implicates the Fourth Amendment in the least impact, is called an encounter. The next ratchet up from there is called a detention, and then the next ratchet up from there is called an arrest. So we have these three separate categories of police-citizen encounters, and they have different components to them, and they trigger different rights and different procedures and protocols. So let's give an example of an encounter versus a detention versus an arrest.
Okay.
You want to take that, or you want me to?
No, you take the first one. Take an encounter versus, and so you guys understand. A lot of times you may hear Michael and I interchange detention with custody. Being in custody is not necessarily being under arrest. Sometimes it can, sometimes it isn't, but mostly being in custody is kind of like being detained, and encounters are not custody and not detention. You take the first one.
So let's say that you happen to be walking up the street, police officers driving by in the car, and they pull over next to you and roll down the window and tap their siren or their horn and say, "Excuse me, sir." That's an encounter.
Right.
You are perfectly free to look at that police officer and say, "Yeah, what can I do for you, sir?" Or to ignore him and keep walking. It only changes from an encounter if that police officer precludes your ability to walk away. So the defining characteristic of an encounter is the citizen's ability to walk away, to not be restricted.
Be free to leave.
I'm sorry?
Be free to leave.
Correct. So in my example, if the officer pulls his car in front of you, blocks your path, gets out of the vehicle and says, "Excuse me, sir, I said stop," you have now been detained.
Correct.
A police officer is like anyone else, whether they're on duty or off duty. They have the right to walk up to you and ask you anything for any reason, but you have the same ability as they do to decline to acquiesce, to engage in conversation, or to answer questions. That's what makes an encounter an encounter. Now, the police officer has to decide at this juncture, well, do I want to ratchet this up? And in order to do that, they've got to have a legal basis, because once you go from a consensual encounter to an involuntary detention, the Fourth Amendment is now clearly implicated. Now, remember, we haven't taken that quantum leap yet to get to the arrest. We're at that middle ground now in between, "Hi, may I speak to you?" and, "Excuse me, sir, you can't go anywhere at this particular moment."
Now, as an aside, briefly, Michael, this is why I said the Fifth Amendment gets implicated many times. If the officer pulls up next to you and rolls down his window and says, "Excuse me, sir, can I speak to you for a second?" and you say, "Yeah," and you say whatever you say to him, it's coming in. He can use everything against you. He did not have to read you Miranda because the cake was not baked. At
Correct.
that point, he was asking you questions. He may even be interrogating you. He may say, "So did you just come from that house?" He doesn't have to read you Miranda because he doesn't have the eggs. He doesn't have you in custody yet. So you're free to walk away. You're free to say no. You're free to hopefully say very politely, officer, if you don't mind, am I in custody or am I free to leave? I mean, if you want, you're free to say, F you, I don't need to talk to you. I wouldn't suggest that. But at that point, you're still free to say whatever you want and you can walk away. So he can ask you whatever he wants without asking you Miranda. You need to know that.
And the same holds true with a detention. So
Correct.
let's say, for example, use the same exact example, only this time, let's say that it's 1 o'clock in the afternoon and you're walking in front of the Seabold building, which for those of you who don't know, the Seabold is a major jewelry exchange in downtown Miami. It's
Looking in the
August.
windows.
It's August, and you're wearing a trench coat and a Scully, okay? So the officer pulls over and says, excuse me, sir, and you just keep walking. And now the officer blocks your path, gets out of the car and says, excuse me, sir, I need to ask you a couple of questions. At this point, you have been detained. In fact, one of the statutes we're going to talk about is 901.151, which is Florida's stop and frisk law. And that would actually be very applicable to this situation that we're talking about right now.
Right.
So the officer now is thinking, wait a minute, why is this guy walking around in front of the Seabold building, furtively looking in and out of windows and looking over his shoulders, wearing a trench coat and a Scully with, 97-degree weather, 95% humidity, and a feels like factor of 114? And based on the officer's training and experience, he may have a reasonable and articulable suspicion that you are up to no good. You are casing the place for a burglary. You're planning a robbery. And so therefore, he would be entitled to detain you under Florida's stop and frisk law and ask you some basic questions to either confirm or dispel the suspicion. Right. So the issue now, I don't want to really get into the Miranda component of that so much as the detention component.
Right.
Because you are being detained. Make no doubt, you are not free to leave.
You're
This
not.
officer right now is engaging in the one thing that he probably never did in his entire life, which is calculus. Okay? He probably never took calculus.
Hey, I didn't take calculus, all right, buddy?
But what he's doing right now is a calculus to figure out whether or not what's going through his mind based on what he knows and what he sees is actually potentially criminal behavior, or is there an innocent explanation? And so he can detain you under Florida stop and frisk law against your will to either confirm or dispel that suspicion. So if we want to take that Fifth Amendment tact, right? Let's say that you take the position of saying, oh yeah, you know what? I'm waiting for my cousin or uncle, whatever, you give any explanation that you want to give. And let's say somehow you have a rational explanation for it. Well, you're on your way. He's probably going to let you go because you have now dispelled his reasonable suspicion. Or on the other hand, if you say the other tact of, no, officer, I don't really feel like talking to you. And by the way, am I free to leave? Because I am leaving. And he says, no, he's got to now decide, am I arresting this guy or not? Because there's no longer any middle ground here. The detention, each of these things has a reasonableness factor, an objective standard that has to be looked at in 20/20 vision in hindsight. So it's always going to be not what was said, but when we look at it backwards, does it make sense, right? So let's take that stop just the way I gave it to you. If he keeps you there for 3 hours, he's going to have a hard time explaining under any circumstances why you were there for 3 hours. If he keeps you there for 3 minutes, not so much. It's more rational. And we're going to give you an example of that later at the end of the show. We're going to take a traffic stop. And I guess we could, just touch on that for the moment for where we are. A traffic stop is not a consensual encounter. When a police officer puts on his lights and sirens behind you on the road, you are being detained, okay? Make no doubt about it. You're not under arrest, but you are being detained. And you are being detained for a specific purpose. Whatever the basis of the traffic stop is, if you were speeding, if you were weaving, if you failed to use a blinker or a turn signal, whatever violation of 316 or even 320 or 322 they may observe. Maybe you have defective equipment, or maybe your tag is expired, or maybe your driver's license is not a plate is not assigned to the vehicle. Who knows? There could be any of a number of reasons, but whatever it is, the detention, which is merely a detention for the investigative purpose of that particular basis of the stop can last only as long as is required to complete the purpose of the stop. So
And
let's say I pulled over
that's
for
the
speeding.
$1 million question, isn't it? The $1 million question is exactly how long is it reasonable for a traffic stop?
So there's no line in the sand time. The law says as long as is necessary to reasonably complete the purpose of the stop. So how long? The answer is however long it takes the cop to get you pulled over, to provide your identification, your insurance, your vehicle registration, to run your driver's license, to run your vehicle registration, to run your insurance, and then issue a citation. That's how long. It might take 12 minutes, it might take 23 minutes, but if they keep you there for 3 hours to do that, it's going to be per se unreasonable.
Right.
But again, I don't really want to spend too much time on that because at the end of the show, I want you and I to get into a more fact-based scenario where we're going to take that exact same thing, let's call it a speeding stop, but we're going to turn it into and let it morph into a worst-case scenario, right? A DUI investigation, other crimes that occur, statements that are made, actions that are taken. We can have an awful lot of fun with that. But
that'll be a good moment for us to also give you some tips on what to do in that encounter. Where if you like everything else, knowledge is important. If you understand what you're doing, there may be a situation where you actually want to trigger being seized. You want to actually trigger being in custody. For example, one example might be because you want the clock to start ticking. You want this reasonableness stop to start kicking. So you may want to intentionally put yourself in custody if you know the cop is already looking to harass you. So he won't drag this out. But we'll get to that when we get to that part.
So let's go back to the Fourth Amendment, right? Unreasonable searches and seizures.
Mm-hmm.
So we're talking about a seizure now. So just like with searches, some searches have warrants, some searches don't. In fact, Ed and I argued and agreed that in reality, probably 95% of all searches are warrantless searches. Because again, most of them are incident to arrest, or they're searches that are conducted pursuant to an impound or an inventory protocol. And because of those factors, no warrant is required. Well, similarly with arrests, some require warrants. The vast majority do not.
Right.
So what is an arrest warrant? An arrest warrant is an application by somebody who is qualified to make application to a judge, whether that's a police officer or a probation officer or a parole board officer or an assistant state attorney, whomever it is that's authorized by law to go in front of a judge and present sworn testimony that alleges probable cause that a specific individual committed a specific offense within the jurisdiction of the court. And based on that information, the court is being asked to issue a warrant. That would be a traditional arrest warrant. But again, most arrests do not happen by warrant. So let's go back to the traffic stop. I get pulled over for speeding. The officer smells alcohol on my breath. He offers me roadside sobriety tests and a breath test. Whether I take them or don't take them, whether I pass them or I don't pass them, ultimately he arrests me for DUI. He never is going to call a judge and ask for a warrant. He's just going to make the arrest. Why? Because the crime occurred in his presence. Or according to him, the crime occurred in his presence.
Right.
And again, we'll get to the specific statute on that in a moment. But there are all kinds of arrest warrants. And again, these are things that we've talked about in other shows. But
you want to give an example of in that same exact scenario where there might be a reason for them to get an arrest warrant, the officer, rather than arresting you on the scene. For example, there's a car accident and you're airlifted to Jackson. Well, the officer couldn't really do a DUI investigation on the side of the road, but he saw maybe beer cans, or while he was there on the scene, he smelled alcohol, or your driving pattern led him to believe that you might be DUI. He can then now continue his investigation, and there he will get an arrest warrant, or can get an arrest warrant later on down the road, a week or 2 or 3 down the road, when he gets your blood analysis and it shows that you were, he gets an arrest warrant so that they can go to your house and pick you up.
Exactly. And again, another subject I want to do, we're going to do a whole show on DUIs, but let's just run with that for a second. In every DUI fatality and most DUI serious bodily injury cases, The first thing that the police are going to do is apply for a search warrant to get your blood. Whether you're airlifted to the hospital or not, whether you're perfectly conscious, whether you are singing and dancing, I don't care what you're doing. If there's a dead body and somebody's bleeding out and has to be taken to the hospital, they're going to get a search warrant.
And hopefully if there's a dead body, you're not singing and dancing on the side of the road.
Well, but you may be, because, you know, drunk people do stupid things.
Well, so, it won't help us when we go to represent you.
Yeah, especially if there's body-worn camera. It's not going to help. Don't dance, please. So they're going to get a search warrant first. And then they're going to take that blood sample that they get, and they're going to submit it to the lab, and it's going to be analyzed, and that's going to take weeks. So after that comes back and shows that you're positive for benzos, cocaine, and opiates, as well as had a blood alcohol content of 1.7,
when it shows that
you're going to go directly to the judge.
When it shows you've been partying like you were a Rolling Stone,
yeah, they're definitely going to go to the judge, and they're going to secure that arrest warrant, and that judge is going to sign that warrant very quickly. But there's other types of arrest warrants too. That would be the most traditional arrest warrant. But think about, you've got like a violation of probation is an arrest warrant. If you're on probation and your PO can physically come cuff you and take you in at any point in time. But they generally don't want to do that. They don't want to see you. They don't want to run the risk. Even before COVID, they certainly don't want COVID, but they don't want to run the risk that things are going to go south and they're going to get injured. It's just too easy to go to the judge and say, Judge, issue a warrant, and then they hand it off to the sheriff and let somebody else deal with it, right? Let them run the risk. But that is an arrest warrant in the form of a probation warrant. You also have fugitive warrants, or what we call alias capiases, or bench warrants. If you have a court date in criminal court and you don't show up, guess what? The judge can issue a warrant for your arrest from the bench.
On their own.
Bench warrant, right?
Right.
That's also failure to appear. You have failure to comply warrants and contempt warrants. You have writs of bodily attachment. Then you have holds and detainers that can be placed on you, which are basically like an arrest warrant. So let's say that I get arrested for anything. I don't care what it is. I'm booked into the jail on crime X, but I am not an American citizen. And immigration gets notice of the fact that I'm sitting in the Dade County Correctional System under arrest. They can levy a hold, which is basically an arrest warrant, that says to Dade County Corrections, do not release this individual under any circumstances to anyone but us. We don't care what happens in your case, but we're getting our pint of blood as soon as you're done with them. And therefore, you're basically being held on another arrest warrant. So these are all different types of Fourth Amendment warrants, right? And there are a bevy of Florida statutes under Chapter 901 that cover all of these warrants. So we're going to go through some of these with you, just kind of run down the list and talk to you about them quickly and see if we can get an understanding. So let's start with 901.02, issuance of arrest warrants. Tell us about that, Ed.
Well, you already covered all the different arrest warrants, but the one thing you need is a bare minimum of probable cause. Before you go to the judge, whoever is requesting the arrest warrant has got to give the judge enough evidence under a sworn statement, either an affidavit or the judge will swear you in right there and you'll tell the judge personally. And you've got to provide them with enough evidence to cover probable cause. Now, what is probable cause? We've covered this in the past. When I used to teach at the police academy, I think the simplest way to explain it was what I would tell the officers. The question you have to ask yourself is it more probable than not that a crime is being committed? That's it. It's that simple. And if the judge agrees with you, then he'll give you the warrant. But that's the bare minimum.
The only addendum that I would add to what you just said is that there are some times where you don't need that because the judge has seen it themselves. For example, contempt.
Right.
Or failure to appear.
Right.
No statement of probable cause is necessary under those circumstances. Let's jump up to the next one, 901.04, direction and execution of warrant.
Wait, which one are you?
Handy, or you want me to run?
No, you take that one. Let's take them so they don't get bored with my voice and my face.
So basically what this says is that any warrant that's issued by any judge in the state of Florida goes to every sheriff in the state of Florida. So basically all warrants are statewide warrants. Now, that can be expanded. The judge can expand it to make it an extradition warrant, for example, or a fugitive warrant requiring or requesting extradition anywhere. They could go within 100 miles, within the state, within 500 miles of the state, in the entire United States. They can even go international.
Right. They can even flag your passport, basically with Interpol. So your passport can be flagged as well.
But the thing about this statute is that A, your arrest warrant is statewide. B, you still have to be arrested unless it's a fresh pursuit or hot pursuit, thing. You still have to be taken in by a sheriff in your county, right? So ultimately, you have to be, if you're a Dade County warrant and you get picked up in Pensacola can take you into custody, but they have to tender you to Dade, and then you have to be brought by your Dade sheriff into your Dade judge.
If I may, actually, Dade County needs to request that you be extradited. They have 14 days to do that. If they don't do that within 14 days, you can post a bond wherever county you're in. But they have 14 days to get you to their county. And then there you may or may not be able to get a bond. But if they don't pick you up, or they don't do anything to get you extradited, forgive my finger, then they have to do it within 14 days. And if they don't, then you can post a bond with the county you're in.
So let's talk a little bit about 901.15. This is a biggie. This is warrantless arrests. This is, when can a police officer make an arrest without going in front of a judge? And again, remember, we told you it's probably 95% of the cases are done this way. There is no judge involved. Your judge is the judge on the roadside. Your judge is your arresting officer. Now, they're not your judge of your case. Obviously, they become a witness and an adversary, and they're subject to attack, on any of a number of grounds. We're only limited by our imagination. But at that particular moment, when we're talking about is Haber or Martinez or John or Jane Q. Citizen going to get arrested, your judge is the cop. So when can a cop make an arrest without a warrant?
When he feels he has probable cause. Let's say he either witnessed the crime himself, or feels he.
That's number one. If an officer observes a crime being committed in his presence or her presence, that's it. An arrest can be made, and it doesn't matter whether it's a felony or a misdemeanor. If it happens in their presence, they do not need a warrant.
Right.
The second is probable cause, right? But that only applies to felonies. So you cannot necessarily be arrested. There are some misdemeanor exceptions, and we'll talk about them. But the general rule is, if the cop doesn't see it, then they need probable cause to make an arrest, and it's got to be for a felony. Okay?
Right.
So if I identify Ed as the guy who jumped me in the parking lot and used a firearm to rob me, and the police then go arrest Ed, they did not see it. They do not know anything about it. There's no video. It's my word alone. But if they believe me, if I am credible enough, then they can arrest Ed and they do not need a warrant.
And that's crucial. You know why, Michael? Because this happens a lot to people. If I just may briefly explain this. So let's say Michael calls the cops and says that I threatened him with a firearm. And for sake of this discussion, Michael is lying. Michael's just flat out lying. He's making it up because he's, whatever reason, he's pissed at me because I'm better looking. And the cop comes to talk to me. Now think of yourself, an everyday average citizen watching people at work or your kids or at home. If you get hysterical, if you try to hide things, if you tell the cops, I'm not going to tell you nothing, which is a double negative to begin with, which means you have to tell them something.
That's when you, that's when you want a jury of English majors.
If you say, I'm not telling you a damn thing, what would you do if your daughter said the same thing to you when you were asking her a question about anything? You would start thinking they're lying. Why are they so hysterical? Why are they so combative? So if you're in that situation, remember that the officer is assessing your credibility. Be very careful with that. And
also remember what Ed said earlier. Anything you say can and will be used against you, whether you've been read Miranda or not.
Right. So you may not want to speak to them, but be polite and be calm and say, look, I would say, look, officer, I respect you very much. I'd love to tell you everything that's going on, but I want my lawyer present because Mr. Haber's a liar. Well, can you tell us what happened? Yes, he's lying. That's it.
The why of that is another show that Ed and I are working on for you guys is going to be a show on adages. And one of the adages that we'll talk about is cops have an adage. It says you could beat the rap, but you ain't beating the ride. Right. So, you have to remember that sometimes, even though you think you're saying something that's going to help you, it may not necessarily.
Right. And so getting back to the warrant, the cop is going to assess what Michael says, what I say. He's going to look and see the credibility of who's talking here. And now if I got hysterical, he might say, oh, this guy looks like he's got something to hide. If I said, officer, I respect you very much, and I'd love to tell you everything that happened, but I need my lawyer present. All I can tell you right now is that Michael Haber is a flat out liar. I never threatened him with any gun. I never even met him in the parking lot, but we'll tell you all that later if you'll let me speak with my lawyer present. See how very calm I am? And they might say, yes. Oh, this guy sounds
just like a cucumber. So obviously you do not need a warrant if somebody's taken in on a warrant, right? So right. If I'm picked up in Pensacola on a Dade County warrant, they don't need probable cause and they don't need any permission from a judge. Right.
They're traveling on the warrant that was already issued.
So here's a couple of exceptions to the misdemeanor rule. Any violation under Chapter 316, which is a traffic, basically the chapter that covers traffic moving violations. So right. DUI, they do not need a warrant to arrest you for the misdemeanor offense of DUI. Reckless driving, they do not need a warrant to arrest you for the misdemeanor offense of reckless driving. Any driver's license, tag or license violation that falls under that chapter, they do not need a warrant to arrest you for those misdemeanor offenses. Obviously, if they get ratcheted up to felonies, then they don't need a warrant for that either. And another one would be domestic violence.
Right. That's the big
misdemeanor domestic violence assault, or misdemeanor domestic violence battery, or misdemeanor domestic violence stalking. Anything that's non-aggravated that does not bump up to felony level, you still get booked and you get taken to jail on those.
Without a warrant.
They don't need to get a warrant. All they have to have is probable cause that the act occurred. Now remember, with the DUI, it may or may not occur in the officer's presence. A lot of times you get a DUI officer that's called to the scene by a traffic stop who just basically did a stop and is handing the case off, acknowledging that he doesn't have the skill or expertise to do the DUI. So we have another thing called the fellow officer rule, but that aside, the DUI did not occur in the officer's presence, yet he can still arrest you for it. Well, same thing with DV. It's very rare that police show up during a domestic incident. 99 out of 100 times or more, 999 out of 1,000, they're dispatched after the incident has occurred. But if they believe that the evidence shows that there is probable cause to believe that I committed an act of DV, then they can and they will arrest me for it.
Right.
And then there's a bunch of other, things in this statute that we could get to. Let's jump over to stop and
pretty simple and basic, pretty basic and simple. Most of these exceptions, like the DV exception, is for citizen safety. Right? If an officer could never arrest anybody on domestic violence unless he saw it happen, first of all, 90% of or more of domestic violences do not occur in the presence of anyone, right? They occur in private. And can you imagine an officer gets out to the scene and some woman is beaten, but he didn't see it, so he can't arrest anybody? So that's why those exceptions are there.
Well, and the other thing is that felonies are traditionally much more serious offenses than misdemeanors. Right. So, you have a misdemeanor for jaywalking, or you have a misdemeanor for shoplifting. You don't necessarily want these people, being railed through the system and have all of those resources tied up when you can give someone a simple PTA.
Right.
By the way, a PTA is an arrest too.
Correct.
And I don't know if we have that statute on here or not, so I'll just throw that out right now. There are some cases where a police officer has discretion, and that means that they can decide to either take you into custody or to give you what's called a PTA, a promise or an NTA, notice to appear. And that routinely happens in traffic cases. Like, for example, reckless driving. They don't take most reckless driving operators to jail unless they have were unbelievably reckless, or if they have a horrible prior history the officer can see when they pull up the driver's license, or that person gave the officer a lot of attitude and a hard time on the roadside. But most times they're going to let you go with the ticket and just you have to show up in court, or you end up with an FTA, failure to appear warrant.
You know what they're doing
with shoplifting.
Right. And you know where they're doing also a lot of PTAs now is possession of marijuana or smoking a joint in the street or something, where it's so blatant that they
it's another
can't look the other way. But
and on those cases, a lot of cops have jurisdiction to not write you at all.
Right.
They can give you a civil citation.
Right.
So let's go up to method of arrest by officer without
You
warrant.
don't want to do stop and frisk?
I think we covered stop and frisk enough.
Okay.
You know, I think we got enough on that. Let's go up to 17. Method of arrest 901.17, method of arrest by officer without warrant.
I don't even know what that means, so why don't you take that? I'm not sure.
I'm going to read it. This is one of these one-sentence statutes.
Isn't that same thing we just covered?
A peace officer making an arrest without a warrant shall inform the person to be arrested of the officer's authority and the cause of arrest, except when the person flees or forcibly resists before the officer has an opportunity to inform the person, or when giving the information will imperil the arrest. Basically, what it means is, if you're being arrested, the cop needs to tell you who he is and why he is arresting you, unless you decide to take off and run or take a swing at the cop.
Or cover, or put your arm stiff, or tell them F you, you guys are pigs.
Which leads right into the next statute, which I absolutely love, 901.18. So in Florida, police officers are authorized by this statute, 901.18, to deputize citizens in that moment to assist them to effectuate an arrest. I don't know about you, but I have lived 55 years on this planet, and I would love an opportunity to effectuate an arrest or two. I've never been deputized, but apparently this statute allows it.
I have never been deputized, but I did do a citizen's arrest.
Tell us.
Huh? Oh, God, it was years ago. We had a check cashing store over on Biscayne and 89 in the late 80s. And there was a gang, a youth gang. Well, it was part of the gang, but this was the youth part of it. Because if you don't understand how gangs work, gangs have the adults that started off as young, but they realize that they can get in big trouble. So they keep recruiting youngsters. And for a lot of these burglaries and a lot of these other minimal crimes, they let the minors do it because they go to juvie and nothing really happens to them because it's civil. So we had this gang right up the street, and we shared a parking lot next to us with the insurance company. And they used to break into the car. I should have
asked you if this was going to be a long story.
I'll make it quick. They used to share. I'm almost done. We used to share a parking lot, and these kids used to break into the cars and steal the radios and whatever people left in the cars. But nobody had done it to any of my clients, so I didn't care. One day I'm coming back from the gas station across the street, and I look into the parking lot. Sure enough, I see some kid backing out of the car with a radio, and he takes off running. Now I'm across the street. It's Biscayne. There's no way I'm going to catch him or anything, and I don't even know whose car it is. But I had a friend of mine who was coming to the store to do his taxes. As soon as I walk in, I see his face, and I said, "Let me ask you a question. Do you drive a Toyota Tercel?" He's like, "Yeah, why?" I'm like, "Oh my God, they stole your radio." And I knew the kid from the neighborhood. So I went to where he lived. My landlord came. He told me where the kid lived. We showed up. Sure enough, he's walking out of his house with a radio in a bag. I just yanked the bag out of his hand. He looks at me and says, "You can't do that. You don't have a warrant." Funny enough. And I looked him in the eye even back then and said, "I don't need a warrant. I'm not a cop. Sue me." So I took the thing out of the bag, and sure enough, it was my buddy's radio. And we were there in my landlord's car. And all I did was look at the kid and said, "Get in the car." And he got in the car. So we took him back to the check cashing store. We put him in there, and we called the cops on him. There you go.
For those of you who are still awake, the statute that I just read to you, 901.18, that allows deputization, also affords protection from civil liability for any deputized citizen. So if a cop does deputize you, you are immune. So
in my case, I was not, because I did a citizen's arrest.
Let's go up to 901.19, right of a police officer to break into a building. You all will probably remember the Breonna Taylor fiasco. That's where the officers, where were they? I think in Kentucky, maybe? Yeah, in Louisville. They did a no-knock warrant and wound up shooting her in the crossfire between her and the person who they thought they were looking for. Complete mess. Well, in Florida, we have a statute that addresses an officer's right to break into a building when serving an arrest warrant. And basically, they have a 100% right to do so. Okay? Yeah, it's cut and dry.
But they have to follow certain parameters.
The first thing that they have to do is they have to announce their authority and their purpose. It's not a no-knock. It's not a no-knock, no-announce. So they are required to announce their authority and purpose to make their arrest. And it's got to be for a felony, and it's got to be, it could be without a warrant, but it's got to be a felony arrest. The officer, quote, may use all necessary and reasonable force to enter any building or property where the person to be arrested is or is reasonably believed to be.
Right. And that's what I want to talk about. Because typically, I mean, I've been doing this for 20 years. I was a state attorney for years, and I've issued many arrest warrants. And
You've never issued an arrest warrant.
Well, I filed for one.
Yes,
I had a judge.
Okay, there you go.
Right.
I judge.
And right. And
Judge Dredd.
Maybe one day I will be filing them. But anyway, the issue is this. Cops, especially in Dade County and in Broward County, they don't usually break your door down. I mean, you've got to be like a serial killer or a mass murderer for them to do it. And this is why, because of the last part of that statute. They have to where is it? Know that the person, or reasonably believe that the person they're going to arrest is in the building. So here's the problem. They could have my driver's license and I could be registered to live in a specific home, but that doesn't mean I'm home, right? Could be out. I could be on vacation. I could be somewhere else. So they break that door down and they're trying to arrest Ed Martinez, and Ed Martinez is not there. They're going to have a problem. They're going to have to explain why they reasonably believed. So what could they say? I saw your car in the driveway. Doesn't mean I'm in the house. The only way they reasonably can say that they think you were home is if they say, we literally saw him walk in the door 2 minutes before we went up and knocked. So what they'll do is this. The sheriff's department here in Dade County, they'll go to your house and knock. Nobody answers. They'll park right down the street watching your house for about an hour or two, depending on how much time they have, because that's all they do. Warrants. There's a warrant department for Miami-Dade Police Department, Sheriff's Office. That's all they do is going around picking people up on arrest warrants. So they'll look to see, or they'll knock and somebody answers and they'll say, yeah, I'm here to see Ed Martinez. And I literally could be Ed Martinez. And unless they have a picture of me that's crystal clear that it's me, I could tell them, I don't know, he's not here. And they won't try to arrest me because they know that sooner or later you're going to have to leave the house. And they don't want to run the risk that a good attorney like Michael Haber and an average attorney like myself will file a motion saying they could not possibly reasonably have believed that the person they were going to arrest was in the home. So that's why, although they can, they usually don't do, because look what happened with Breonna Taylor. Exact same problem. Had they just waited for that guy to leave that apartment, they never would have had that problem. Do you want to say it?
Yeah. Let's run on to 901.24. And this is one that I've been very much looking forward to talking about.
All right.
And actually, you're going to do a little more talking than I suppose, on this one. But
no, I'm going to
901.24 is right of person arrested to consult attorney. And again,
I don't want anybody to accuse me of being a bully, Michael. So I'm going to try and stay quiet today.
It's one sentence. Literally, the statute is one sentence. A person arrested shall be allowed to consult with an attorney entitled to practice in this state, alone and in private, at the place of custody, as often and for such periods of time as is reasonable. This is huge, okay? And this is one of these where you read the statute and what you read and what the real world applications are completely different. A plain reading of this statute would suggest that if I get arrested for anything, anywhere, at any time, all I have to do is say to the officer, all right, stop. I want my lawyer and I want him here now. And they got to provide him.
He's got to bring him. As long as I'm in custody.
Except that ain't going to happen.
Never does.
Years.
Never happens.
So why is it that the statute says alone and in private at the place of custody as often and for such periods of time as is reasonable? Why does it say that? And why is that not accurate?
Is that rhetorical or you're asking me?
Both.
Okay. Well, and I looked it up, Michael.
Actually, put on your philosophical hat and give me a rhetorical answer.
Okay.
Come on, Descartes.
I'll do my best.
Okay.
I tried to look it up. There's actually there's almost no case law on this. And Michael, you've been doing this for 30 years. I've been doing this for 20 years. And I've never seen once, or never have I heard of anybody challenging this statute. And here's what I believe is the issue. When the officers have you in custody on the side of the road or even at the police station, they're still conducting an investigation. Allowing the suspect to speak to anyone could be obstruction of justice or tampering with a witness or tampering with a defendant. So I believe that the reason is that that statute is in conflict with this statute while the officers are still doing the arrest. But notice
Okay,
once
no,
you
but
get
this
booked,
says, hang on, Ed, because this
I
statute
know.
starts, the first three words are a
I know.
person arrested. This is not a person being investigated. This is not a person being detained. This is a person arrested. The minute that the officer smacks the cuffs on me and says, you're under arrest, this statute seems to imply that they have to stop everything and get me my lawyer if I ask for him.
Correct. Now, here's the other thing, Michael. And I'm sure, I don't know if you guys are going to get bored, but this is exactly what lawyers do all the time. What would be the remedy? What is the remedy? The case gets dropped. It doesn't say the case gets dropped. It doesn't really say what the remedy is. It just says you're entitled to it. I don't know what the remedy is.
My curiosity with this is that it's got no application to the real world. Now, I will tell you, like you said, I've been doing this 30 years. There's only one case that I was involved in where the police actually went out of their way to provide me access to my client while he was in custody. But that's after they flew outside of the United States to kidnap him from the Bahamas and bring him back here. And I think that in an abundance of caution, they let his lawyer come in because they knew that they were going to have all kinds of issues about how they got him.
And
they
it happened
literally,
It happened to me once too. Sorry, I thought you were done. Go ahead.
Yeah, so as a normal rule, I get calls. Now, look, this is, again, the difference between acting out of intellect versus acting out of emotion, right? So when you're emotional about your arrest and you're teeing off on a cop for wrongfully arresting you and not fucking listening to you and not understanding what's going on and being a jerk and blah, 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 they're not going to let you do anything that they don't have to let you do. In fact, they're going to probably go out of their way to make it as uncomfortable for you as possible. On the flip side of the coin, when you're calm, cool, collected, and rational, and you say to the officer, listen, do you mind if I call my lawyer? Do you mind if I call my wife? I can't tell you how many times I've had police officers allow clients to call me in that moment, right there, knowing. And sometimes I even had police officers get on the phone with me so that they can explain to me what's going on. So as a general rule, I find that your attitude and your demeanor is really the controlling variable in regards to the officer's behavior. But I also, based on that one case, which was a really serious, kidnapping, homicide, robbery, it was a brutal case. But because it was so serious in that one, I believe that the police intentionally let me come in. I've had plenty of times where I've tried to get in to see clients who were at the police station to no avail.
Right. And I've been contacted too. Normally it's on murder cases, right? So if they don't really have my client dead to rights and they're not actually arresting him, but they have him in custody because they've taken him into the station and they want to question him. If by the minute that my client says, I want to speak to my lawyer, that's it. They stop questioning because they know the law and they have contacted me to go out. But those are very serious crimes where they don't want to lose the case over something as stupid as not letting the guy speak to his lawyer. But simple batteries and things like that nature, where they've already maybe decided they're going to arrest you and you're just going in already. They're like, we'll let you talk to your lawyer. Don't worry about it, when you can call him from jail.
Right.
And I think, and again, I couldn't find any case law to say what exactly does it mean, reasonable and custody. Are we talking custody like custody on the side of the road?
No. We're talking about arrest. We're talking about people who are arrested, not in custody. Arrested.
Arrest. So what does that mean? Is it if it's in the process of taking him to jail, it's probably not reasonable for him to be able to sit down and speak to his lawyer. But and also it has to be private. So they could argue, listen, he's at the police station. We have him in a jail cell with 5 other guys. That's not private, and we have no way to put him in a private room that's secure.
I think the best thing we can tell the folks on this is just be cool, be polite. If you want to talk to your lawyer, ask the police officer he has a problem with you calling him right from the side of the road. If he does, be respectful. Ultimately, you'll get to make your phone call. And remember, and we're going to do another show on bond and bail and pretrial release, but remember, it's your bondsman, it's your surety that gets you out of jail, not your lawyer. as a general rule. I mean, unless you have a no bond hold, and then it's your lawyer. Let's jump up because we only have a few minutes left.
We're running out of time.
And I just want to hit 3 more statutes before we get into our DUI hypothetical. So, I don't know how many of you have seen the movie, but it's one of my favorites. It's classic. It's one of the Lethal Weapon ones. I don't remember which one. It might have been number 2. I think it was number 2.
That's South Africa?
Yeah. Right?
I think it is
Diplomatic immunity, Officer Riggs. Well, we have a statute, 90126, for arrest and detention of foreign nationals. This is not for diplomats themselves. This is for citizens of other countries that get arrested here in the state of Florida. The Vienna Convention, which we're not going to get into now other than to say that it exists, and basically it requires that every participating country honor the sovereignty of other participating countries. So if you're an American and you get arrested in Belgium or in Germany or in Thailand or wherever the hell you may be, then they probably have similar protocols to this statute. And this statute says failure to provide consular notification under the Vienna Convention or any convention is not a defense in a criminal proceeding against a foreign national and is not cause for discharge from custody. So basically what they say is you got to let the embassy know. You got to let, if we arrest a Venezuelan citizen, we got to let the Venezuelan embassy know. Maybe that wasn't the best choice of countries. If we arrest a British citizen, we have to let the UK embassy know. But a failure by law enforcement to do that does not equal a dismissal.
Right.
90128, notice to appear and promise to appear, we kind of touched on a little bit. That's basically, again, some crimes police officers have discretion. And it's the same thing with that asking the cop to call your lawyer on the roadside. The more pleasant and less combative and neutral the encounter, and let's call it the experience is, the more likely the police officer is to cut you slack and treat you good. And where they have the discretion to just give you a ticket and say, look, you'll get a court date in the mail, don't worry about it, or take your ass to TGK, book you, cost you a mugshot, a very uncomfortable evening, having to appear in front of a judge or post bond, then deal with all of the consequences that stem from that. You're going to wish that you had been a little bit more pleasant about it if you had the alternative. And then finally, the last one that I want to talk about is an interesting one. And this comes up an awful lot. I get this. I get a lot of questions on the internet, through social media, through my various platforms. And this is a repeat. This is a constant repeat question about, do I have to show my identification? Do I have to give the police officer my name? So in Florida, Statute 90136 requires that it prohibits you from giving a false name. Right. Or a false identification. So it's not so much that you can't say nothing. Theoretically, you can. But if you intentionally or knowingly or provably give false information, you commit a crime. So if you have a fake ID and you tender that fake ID, you're committing multiple crimes. All right? If you have, this is one I've had many times too, I'm sure you have, Ed, there's always the knucklehead black sheep sibling, right? The one sibling that has a suspended driver's license and is in and out of trouble all the frickin' time. And when they get pulled over, they say to the cop, oh, I left my license at home, but they give their brother or their sister's name and date of birth.
Because they know their brother doesn't have any priors and doesn't have any
Exactly. And now that person has a whole new mess to deal with because the officer trusted him and didn't take him into custody. But you've now committed another offense. So apart from screwing over your sibling, and apart from whatever crime it was or infraction it was that you committed, and by the way, this happened with a traffic stop, right? Not even a crime. Let's say you get pulled over for speeding and you give a phony name. That's a crime. Right. So these are among the many statutes. There are more that we had that I didn't get into because we're running low on time. We've only got about 5 minutes left. So I just want to throw a hypothetical that Ed and I can go a little back and forth with to give you some idea of just how bizarre and amorphous and limitless and imaginative and extensive the possibilities can be. And let's just take it with a basic traffic stop for speeding. You get pulled over for speeding. That is a detention. As far as the Fourth Amendment is concerned, you have been detained. As we discussed, the officer has the right to keep you as long as it takes to complete the purpose of that stop. Maybe it's 8 minutes, maybe it's 18 minutes, whatever it is, however long it takes for the officer to run your credentials and then write you a ticket.
Right.
But let's say the officer figures this guy's a doper. I know it. Maybe he smells it. Maybe he's just got a sixth sense about him. Maybe there was something that triggered the thought. And he says to you, hey, do you mind if I search your car? And you say, oh, matter of fact, I do mind, sir. No, I'm not going to let you search my car. And he says, all right, no problem. Goes back to his car. While he's doing your paperwork, he calls in for a canine and says, I need a canine out here right away because I think I got a vehicle full of dope.
Right.
So now the canine shows up. And the canine walks around your car and does a search. I know we're talking about arrests here, but bear with me. It's a search. That is 100% lawful, by the way. No warrant is needed for the police officer to have a canine walk around your car. You have no expectation of privacy in it. But let's get back to the detention, to the seizure. Because if it takes that canine an hour to get to your car, and that officer keeps you on the side of the road for a speeding stop for an hour waiting for a canine, I don't care if they find 50 kilos of cocaine in your trunk, it's not coming into evidence because they violated the Fourth Amendment, unless they have some independent way to get it in.
Just so we're crystal clear, the law does not have any bright line time limit. And as a matter of fact, even when Michael says, well, when they stop you for a traffic infraction, that's a detention. That's a little bit of a gray area too, depending on how the cop phrases it. But I'll tell you where it's not a gray area. The law says crystal clear. There is no doubt you are detained the minute an officer physically takes your driver's license from you. Because at that point, you're not free to leave.
So let's take our scenario as we have it right now. The officer's got my driver. You and I, you're the passenger in my vehicle, okay? The officer's got my driver. Huh?
We got 3 minutes to do this. Go.
Okay.
Go.
The officer's got my driver's license, and you decide, hell with this, I'm out of here. And you, as the passenger, open up the door and start walking away. And the officer says, hey, where are you going? Get back here. Have you now been detained? Does the officer have the right to keep you on the scene? Can he forcibly detain you?
Okay, so those are 3 questions. 1, have I now been detained? Absolutely. He gave me a lawful order to stop. Now, I personally would turn to him and say, are you detaining me or am I free to leave? I want to hear it.
I'm detaining you, sir. Get back here.
Then that's it. I stop. Those are the magic words. He's detaining me. Now, he's going to have to articulate what the hell he's detaining me for. And at this point, I don't know.
The next point, reasonable and articulable suspicion, right?
But that's not your job as a citizen on the side of the road. You just say, okay, I'm detained. Okay, I'll stay right here.
But what if you don't stay there? What if you decide, I haven't done anything wrong? Haber may be DUI. Let's say the officer has smelled alcohol and he has said to me, sir, have you been drinking tonight? And I say, no. And he says, okay. And he goes back to his squad car. We know he's going to conduct a DUI investigation. You know that I'm going to be on the side of the road forever, and you just want no part of it. And you say to this cop, look, I understand you're telling me to stay here, but guess what? There's no reason for me to be here. I'm not driving. I don't know what's going on. This guy, you think he smells of alcohol? Guess what? So do I. I don't like it. I don't want any part of it, and I'm out of here.
Yeah.
Now what?
You could even tell him, you think he smells of alcohol? You're right, because he had about a fifth of vodka, and I had an entire bottle of vodka. It's not illegal to drink. You weren't driving. So you can say, so I'm out of here and I'm walking home.
Right. And then you wind up tased and accused of disorderly intoxication. So, but now my point being, let's say it switches up to from a traffic stop for speeding, and now the officer smells alcohol or sees bloodshot eyes or whatever reasons he decides to escalate it to a DUI investigation. That detention clock now resets because it's a whole new ball game. It started, and he only could keep you there long enough to deal with the issue of speeding, but now it is morphed into a DUI criminal investigation. And so now the clock starts ticking again.
But however, the passenger's clock is still on the original time clock because he couldn't even possibly arrest me for DUI. So my detention clock started when he told me I was not free to walk away.
So let's say that you and I are passengers. He does that. You try to leave. The officer says no. He tells you you're detained. You decide not to argue with him and stay on site. He arrests me for DUI. and he impounds my vehicle, and inside the glove box, he finds a kilo of cocaine. And
Ah,
now he charges both of us, you and I, with arrests us both for trafficking in cocaine.
correct.
Now what?
And he can. And that's my new clock. That's my new custody clock, because now I'm being held in custody for the cocaine. Originally, I was being held in custody because he's going to have to articulate what the hell he was holding me in custody for. But if he gets to the cocaine quickly enough, I think he'll be okay. I think it'll be an okay arrest.
So the point of this exercise is to illustrate how quickly things can go sideways and how many different possibilities there are. And forget the cocaine, the kilo of cocaine. I mean, there could have been a firearm. Let's say that Ed is a convicted felon, and there was a firearm underneath the passenger seat, and they don't discover that until after Ed's already left the scene, and my car has now been impounded and inventoried. They could then go seek an arrest warrant for you for possession of a firearm by a convicted felon. So this is kind of how it all ties.
And that is exactly why most officers have been doing it for years. Will not let the passenger just walk away from the scene. That's why.
So
because
this is how these things can spin, and they really can get a little bit crazy. We've seen an awful lot in our time, so it's very hard to share it all in the course of an hour, which we have now actually exceeded.
Yes, this is a prime example, if I may, Michael, of why you can't get a law degree by searching Google. You can't get a law degree by trying to use your common sense. The law is not common sense. It's very complicated, and we could sit here talking about this subject probably, Michael, for 8 hours? Easily. Okay? So this is why you need to hire.
You certainly could.
This is why you need to hire a lawyer. Listen, we all do what we do best.
Let me just say thank you to everybody for being patient with us.
Yes.
This is the first time that the two of us have appeared by Zoom. Hopefully the last. I'm actually eager to get back to the studio.
Me too.
I hope that next week we're going to have a guest. I'm working on bringing a guest in next week, but if not, we'll always have an interesting episode for you, something intriguing to discuss, and hopefully we'll be able to give you some pro tips and help you out. And in either event, we're always happy to be at your service.
Correct. And we got to go, because if not, Grant's going to fine us for being 5 minutes over. So.
Oh, and I do miss you guys. So, just Grant, Mike, Howard, Tommy, and especially Georgia, we miss you.
Yeah, I miss everybody except Grant, but that's okay. Anyway, take us out, Michael.
See you next week. Take care, guys. Thank you.
Bye.